I know that'll work. I know that'll work. Yeah, it's
what this case is about. In 2004, the city of Corsicana in Navarro County offered sales tax incentives and entered into economic development agreements with a nonprofit property owner, the Corsicana Industrial Foundation, to facilitate the development and construction of a Gander Mountain store in Corsicana, which would serve as an anchor for a new 132-acre shopping center. Those sales tax incentives would then be used by the foundation to help pay back a $10 million loan from my client, Chase Bank, that was used to construct the Gander Mountain store. The city and county achieved their goal. And for over 11 years, everything went as planned and as the parties agreed. The foundation obtained a loan and they built the Gander Mountain store. The store and the entire shopping center opened, which generated additional sales taxes, property taxes, infrastructure, new jobs, and other economic benefits for the city and county. In every quarter, the city and county remitted approximately $150,000 in sales taxes to the foundation to help the foundation pay back the construction loan. In 2015, however, everything changed when the Gander Mountain store unexpectedly closed. Although the city and county had agreed that the sales tax grant would continue until the loan was fully paid off, they unilaterally ceased making the sales tax payments. Instead, the city and county tried to get out of their deal by passing a resolution that the closing of the Gander Mountain store supposedly extinguished the public purpose for their earlier grant. The city and county also filed a lawsuit against the foundation, Gander Mountain, and later Chase, asking a court in Navarro County to declare that the agreements that the city and county proposed, signed, and had performed more than a decade earlier were unconstitutional and invalid. The district court summarily granted that the very relief the city and county requested in a procedure known as a summary judgment. The foundation and Chase appealed that judgment. We're here today asking the Waco Court of Appeals to review the lower court's decision.
I feel like you are to get some kind of award because out of all the attorneys so far, you were the first one to make the 3-minute cutoff.
Preparation.
Put pressure on me.
May it please the court.
You may proceed when ready.
This case raises important issues regarding the viability of economic development agreements in the state and whether local governments should be allowed to flout their unconditional contractual obligations if they change their mind years later. The city and county entered into agreements and achieved the very public purpose they contracted for, the construction of a new retail center. But they didn't fulfill their part of the bargain. I want to spend my time this afternoon focusing on 3 issues. 1, the controlling constitutional and statutory provisions that govern this case. 2nd, why the 3-part test announced in Texas Municipal League, or TML, does not apply. And 3rd, why the grant here easily satisfied the TML test, even if it did apply. I want to start with the Texas constitutional provision and statutes that govern this case. In moving for summary judgment, the city and county argued that the agreements violated a number of constitutional provisions, including Articles 3, Sections 51 and 52, and Article 11, Section 3. But on appeal, they never discuss any of those provisions in their brief. And there's a good reason why. None of those provisions apply to economic development agreements. Nor does this case turn on case law from the 1800s. Rather, this case is governed by the 1987 enactment of Article 3, Section 52-A of the Texas Constitution. That section, which is set forth in the appellant's bench exhibit, unambiguously provides in relevant part that notwithstanding any other provision of this Constitution, the legislature may provide for the creation of programs and the making of loans and grants of public money for the public purpose of development and diversification of the economy of the state or the development or expansion of transportation or commerce in the state. And when interpreting the Constitution, the Texas Supreme Court and this court rely heavily on its literal text and give effect to its plain language. We've cited at least 3 cases on page 12 of our reply brief from the Texas Supreme Court and this court, Henry Lee, Molinet, and Texas Employment Commission, which hold that a notwithstanding clause like the one in section 52-A controls over other provisions. So when you disregard the other constitutional limitations on the grants of public money that don't govern, this case is very straightforward. Section 52-A created an exception to the constitutional prohibition on the granting of public money. It establishes that grants of public funds to assist private businesses to foster economic growth serve a public purpose and are constitutional, and it permits the legislature to enact legislation providing for economic development. That is what the legislature did here. To implement section 52-A, the legislature enacted sections 380.001 and 381.004 of the local government code. Those statutes broadly authorize cities and counties to grant public money and a range of incentives to promote state or local economic development and stimulate business activity. The city and county availed themselves of that opportunity here. In the resolutions and agreements they signed in 2004, they properly invoked their authority under chapters 380 and 381. And they granted public money in the form of sales tax incentives to promote economic development by facilitating the development and construction of a new retail center in Corsicana. The dispositive question for this court is whether this type of economic development program is allowed and constitutional. The answer to that question is unequivocally yes. This is a classic example of an economic development program authorized by the Constitution and the local government code. And critically, the city and county agreed that the grant served a public purpose and promoted economic development back in 2004 when they signed the agreements. We're simply asking the court to hold the city and county to their word. It's really that simple. The city and county permissibly granted public money to promote economic development. The agreements granting those funds are therefore constitutional.
Council, this agreement was done, or this disposition was done on summary judgment. And surely there is still some question of what constitutes a economic development that would meet this provision. First of all, is that strictly a legal issue? And if it is not, is it a fact question that is inappropriate for disposition by summary judgment?
I think the ultimate question of whether something serves a public purpose, it is ultimately a legal question, but the Texas Supreme Court has instructed courts that unless a court can say that the purposes for which public funds are expended are clearly not public purposes, the court is not justified in holding invalid a governmental act. And that's the Davis v. City of Lubbock case and Davis v. City of Taylor case. And so I think the question is a question for the city and county to decide in the first instance. And in this case, they decided in the first instance that these were for economic development and served a public purpose. In the interlocal agreement, I'll quote, they said, quote, "The city and county have determined that it is in the public interest to promote the economic development of the Gander Mountain facility and grant portions of the sales tax to facilitate such economic development."
So you don't contend that they can just label it anything that could be, or that they decide is economic development. There has to be some underlying economic development purpose.
I think so. I mean, I think the court stand is kind of a backstop. I mean, if it's completely arbitrary and capricious, if city and county decide I'm just going to give $10 million to my neighbor for to decorate his house, and I'm going to call it economic development, I think there's a place for the courts to second guess that. But what there isn't a place to do is what happened here. Have the city say, this is the purpose. We want you to build this store because it's going to spur development all around. And then 11 years later say, well, I know you did that, but we really had this other purpose. We want the purpose to be to operate this one store. And if you don't operate this one store, it doesn't pass constitutional muster. I want to shift gears and talk about how the trial court got it wrong. At the urging of the city and council, the trial court made at least 3 mistakes. First, the court erroneously applied the TML test to invalidate the agreements. Second, the court erroneously determined that the closing of the Gander Mountain store somehow extinguished the public purpose of the grant. And third, the court misapplied the TML test, even if it was applicable, to conclude that the agreements lacked sufficient control to ensure the public purpose would be accomplished. I think it's telling that the city and county never really addressed the plain language of section 52-A or chapters 380 and 381 in their brief. Instead, their argument is simply that the 3-pronged TML test applies, and these agreements are unconstitutional because they fail that test. The threshold problem with that argument is that TML does not apply to a grant under section 52-A. In TML, the Texas Supreme Court adopted a 3-part test to determine if a statute accomplishes a public purpose consistent with section 52 subsection A, not section 52-A. And there is a critical distinction between those 2 provisions, which is illustrated in the bench exhibits I filed on Monday. Section 52 subsection A prohibits gratuitous payments of public monies to individuals or corporations. In stark contrast, section 52-A expressly authorizes the creation of programs that grant public money for economic development. I have searched and have not found a single reported opinion from a Texas appellate court that has ever applied TML to a grant under section 52-A. And notably, the city and county don't cite any such authority. We have, on the other hand, cited at least one case, the Reeves County case from El Paso, that upheld the grant of public money under section 52-A without applying TML because the grant was for economic development. That should be the only test under section 52-A. Now, ultimately, I think it's an academic question.
Do you think that the economic development decision can be reweighed by a court or a jury at a later date?
I don't, Jerome. I don't. And I think that would create chaos in this state. There are over, I think it was 3,600 economic development agreements. And if we want companies to invest in this state, we want banks and lenders to loan money to expand commerce in this state, they have to be able to rely on written agreements that are freely negotiated between sophisticated parties.
So a subsequent change in a county commissioner's court or a city council, they can't come back in and reevaluate whether or not it was, in their mind, a adequate economic development.
No, Your Honor, because it would render every contract illusory with the city and state. Who would ever do business with the city and state? Hey, we want you to loan $10 million for this thing. Hey, but by the way, if there's a new mayor elected next year, all bets are off. You know, you get left holding the bag. I mean, it would just, that's the problem with what happened here.
Council, before I forget it, in the context of the arm's length negotiation, is there anything in the record that tells us why section 3.3 got changed?
No, Your Honor, the only thing we have in the summary judgment record is an earlier draft of 3.3, which is the provision that would have allowed the city and county to terminate the agreement upon cessation of operations of Gander Mountain. But as I think the court is pointed, that got taken out of the agreement, and that's the problem here. What the city and county convinced the trial court to do is take a provision that was taken out of the agreement and effectively rewrite it and put it in the agreement 11 years later. It changed the deal. If the city and county wanted that, if they wanted the ability to stop their incentives, they need to leave that provision in. They took it out. Let me turn back. I want to kind of, and this kind of goes to the predominant purpose and where the court kind of redefined it after the fact. In the first part of the TML test requires the legislator to ensure that the predominant purpose is to accomplish a public purpose. Under section 52A, economic development is a legitimate public purpose. The agreements had a public purpose when they were signed in 2004. The city and county have never argued otherwise, nor can they. I pointed out the provision of the interlocal agreement where they said in black and white that they determined this was in the public interest. And they convinced, the problem with the court did is it engaged in revisionist history. The agreements here were not to fund the continuous operation of a single store. Rather, the express purpose was to construct or develop a retail facility. And you don't have to take my word for it because the city and county repeatedly admit as much in their brief. On pages 15, 16, and 18 of their brief, they repeatedly acknowledge that they pledged the sales tax for the quote, construction of the Gander Mountain facility. Those statements are entirely consistent with the public purpose the city and county contemporaneously expressed in the resolutions they passed and the agreements they signed in 2004. Importantly, that public purpose was already achieved more than 19 years ago. The store was built and opened, the entire 132-acre business park was developed, and the city and county generated additional sales and property taxes from the shopping center, as well as other economic benefits that still benefit the city and county today. The notion that the sales tax was somehow tied to the continuous operation is undermined by the terms of the agreement and the change to section 3.3. The lease, which is also specifically referenced and incorporated in the interlocal agreement, reinforces the point. Section 8.2 of the lease specifically states that Gander Mountain, quote, is not required to continuously operate the premises or any portion thereof throughout or during any portion of the term of the lease. And then the last thing I'd point out is section 1.3 of the RCGAs, where the city and county agreed that their obligations to make payments, quote, shall be absolute and unconditional, and that they shall make such payments without abatement, diminution, or deduction, regardless of any cause or circumstances whatsoever. Real quickly, I want to focus on the other argument that the city makes and that the trial court found, which was that the agreements were unconstitutional because they failed to place sufficient controls on this transaction. 2 quick points. Number one, that is from the TML. No court has ever applied that control test to a grant under section 52-A. But even if the court were to do so here, there are sufficient controls in these agreements to ensure the public purpose was fulfilled. Under Texas law, a contractual agreement outlining the requirements that the receiving entity must comply with in exchange for the funds may provide sufficient control over the funds to ensure that the public purpose is accomplished. That's precisely what we have here. If you look back again, the public purpose was the construction of the facility. The agreements here contain numerous provisions that ensured a retail facility would be built and actually was built, and that the sales tax incentive would be used solely to be paid for the construction of the facility. We have extensively detailed those controls on pages 59 to 62 of appellant's brief and pages 22 to 26 of our reply brief. I point out at least one of them for the court, which is section 7 of the interlocal agreement, protects the city from having to deposit any sales taxes in the foundation's account until, quote, the completion and opening of Gander Mountain. In other words, if the Gander Mountain store was never completed and never opened, the city and county were off the hook. They had no obligation to pay a single dollar of sales taxes to the foundation. These and other controls are more than sufficient to ensure the public purpose of the grant, the construction of the building, was accomplished. For these reasons, we'd ask the court to reverse the trial court summary judgment and final judgment and remand the case for further proceedings. If the court has any questions, that concludes my argument.
Counsel, with regard to the third issue, I think you were going to talk about, and with the question, you didn't get there exactly. you said that it easily meets the TML test if it is applicable. Could you spend a couple of minutes on that test and how this meets that test?
Yeah, so the parts of the test that are in dispute is the first part of the test is it for a public purpose?
Okay,
And this is kind of why the TML test doesn't even apply, because the Constitution has already answered that question in section 52-A. Economic development is a legitimate public purpose, which is why we contend TML doesn't even apply here. The other part of the test has to do with the control test. And again, you have to frame the control into the public purpose. Again,
and it was a third element of the TML that nobody disputes.
it was a return benefit.
Okay,
And it kind of overlaps. Yes, there's a return benefit because the city got infrastructure, taxes, and the like.
and if they ceased all operations on the entire development, the city nor the county would owe nothing.
If every store in the whole shopping center closed down, that they have no obligations. Their obligation is only tied to the sales developed by the whole shopping center.
But the city and the county would still be able to assess ad valorem taxes on the property.
Absolutely. And even after the Gander Mountain store closed, and this is in the record, Gander Mountain still was paying property taxes. I mean, that building is still there today. Property taxes are owed, presumably being paid, or somebody would have taken the facility.
Okay. All right, thank you, counsel. You'll have 5 minutes for rebuttal.
May it please the court, I guess. A little bit unusual for me. My name is Terry Jacobson, and I'm an attorney. I practice in Fort Canada. It's Navarro County, not Navarro County. People who live there know that. And what this case is really about, I think the judge earlier, Chief Justice Gray, said that it's about tax law, but it's really about constitutional law. It's about your tax dollars and what controls does the Constitution play on spending your money, giving it to private businesses. Generally speaking, when private parties contract, they can agree to about anything they want to. And then 2 or 3 years down the road, 5 years down the road, one party can't say, I didn't get what I thought I was going to get. I want out of the contract. But completely different rules apply when you're talking about a private entity getting money from a government. It's long been the law in Texas that if you receive tax dollars in your private entity, there's some things you have to do in return to earn that money. And the reason is it's tax money. It's your money. And the contracts we're talking about here don't just bind taxpayers who were in Navarro County in 2004. They bind 20 years worth of taxpayers. They bind taxpayers who weren't born when the contracts were signed. So what the law actually requires is this. The law requires that a contract with a private entity, where the private entity gets government money or resources, has to do 3 things. The contract has to serve a public purpose, always. And the public purpose here, as my colleague, Mr. Pevnik, said, is the development and diversification of the economy, which can only happen if the store actually operates. The second element that has to be met is there have to be adequate controls in the contracts to provide that the government gets in return what it gives its money for. And that's going to be a big issue. We're going to talk a lot about that. The third thing that has to be in the contract is there has to be an assurance that the government gets a return on its investment. And in this case, Gander Mountain opened in 2004. It operated for, I think, about 11 years, give or take. And then it stopped. It closed its store. In spite of our objection, we warned them before they closed the store, they shouldn't do it because the county and city might not be able to provide tax dollars to them anymore if they actually close the store. They closed the store, they went bankrupt, they dissolved, and Gander Mountain is long, long gone. Now the bank still wants the citizens of Navarro County to continue to pay the loan, even though we're not getting anything else in return for our money. The bank has already collected $9 million in loan payments over the course of the loan. It has a lien on 10 acres of real estate, which is valuable, plus a store that was actually built for $10 million. And plus it has a contractual right, a security interest in $5 million in the insurance proceeds. And the bank still wants more. The bank still wants more. Our position is fairly clearly, in order to get government money, you have to give something in return. And when Gander Mountain went away, when it stopped functioning, when it ceased being an operating business, the obligation of the city and county to pay taxes went away as well. In fact, we're actually required not to give money away. That's what the Constitution actually said. So, we have a saying in Navarro County, pigs get fat and hogs get slaughtered, and that's why we're here. We think that the law not only excuses us, it requires us to no longer give tax dollars to an entity that's defunct, it's gone. They provide no benefit today and haven't now for 8 years to Navarro County. And again, we're talking about your money. We're just the stewards. The city and county are the stewards of your money. The money belongs to you. So thank you very much. I look forward to talking to you afterwards, I guess. That's the appropriate way to do it. Whoa, okay, here we go. Judge, I want to start with something that council had mentioned about there not being any cases out there that actually marry Article 3, Section 52A to the TML test. And we have found a case that a little bit indirectly actually does marry the two. It's called Martin versus Hopkins County. You found it yesterday, as a matter of fact. It's at 658 Southwest 3rd, 342. And basically in that case, the question was whether or not some money that was provided to a private business was either a tax grant or an economic development grant. And the court eventually held that it was actually an economic development grant. And on page 352 of the opinion, they talk about Article 3. Actually, they talk about Chapter 381 of the local government code, which actually authorized counties to engage in economic development agreements pursuant to 52-A. And what it says here is the Attorney General also wrote that subsection H leaves the duration and amount of economic development loans and grants to the Commissioner's Court budgetary discretion in the first instance, subject to the constitutional limitations discussed in TML. That's what the case holds. That's what it says. So a Chapter 381 agreement, which is coming from 52-A, is subject to TML. And it isn't just cases that find that. We cited, I think, 5 different Attorney General opinions from 5 different Attorney Generals that link Article 52A-A directly to the TML test. JM 1255, DM 185, John Cornyn 92, Greg Abbott 71 and 529, Ken Paxton 261. Every Attorney General since 1990 has linked the two together. And they talk about 52-A in the context of the TML test. They're there. The government gives the money to a private entity. The private entity is obligated to do something in return. There have to be adequate controls to validate the giving of taxpayer money in the first instance. And I would argue that if Jim Maddox and Ken Paxton can agree on anything, by golly, it's got to be the law, right? I mean, as far as they come from in terms of their political perspective, they agree on it. And we also did something kind of unusual, which I assume you don't see a whole lot. We cited a bunch of CLE materials in our filings. And I know you don't get a lot of that, but what we wanted to show the court was there's a whole body of lawyers out there practicing government finance law that practice law exactly this way. The TML test does in fact apply to a economic development opportunity under 52-A. And excuse me here, I've got 2 more papers and I have space to put them. Not only do I agree with that, actually, the appellants agree with that as well, because in the trial court, the appellants actually submitted an affidavit from somebody that they called an expert witness. His name is Jeffrey Moore. You'll find it in the record on page 818, beginning, I think it's volume 5. And Mr. Moore practices with a law firm that represented the foundation in the case. And what he actually says in his affidavit is exactly what we're saying. 52-A implicates the control from TML. It does. That was his testimony. He offered that as part of the summary judgment rebuttal evidence at the summary judgment stage. So he agrees with us. He agrees with us. The issue was raised about 52-A being self-executing. And of course, there's about 10 or 12 reasons why that's not the case. First of all, Mr. Moore, the lawyer who opined in the trial court on behalf of the foundation, agrees with us. The attorney generals, they all agree with us. The case, the Martins versus Hopkins County case, that agrees with us. And really, if you think about 52-A and where it came from, it makes sense that the public purpose requirements from 52A, little a, parentheses A, would be engrafted into 52-A. The words public purpose don't even appear in section 52. Anyway, they're not there. What it says is public monies. The phrase public purpose comes from courts. Courts developed the idea of public purpose in connection with cases brought by taxpayers primarily in situations where a government was giving money for some alleged public purpose, but there was a significant private benefit involved. We cite the Gillum case in our brief, and the Gillum case involved a situation where the city of Dallas formed a farmer's market. And they rented stalls in that farmer's market to private businesses who brought their eggs, butter, milk, produce, whatever it was they were selling there. And the court talks about the reason that that agreement there is valid is because the city of Dallas retained control over the private entities who were leasing property from the city. They had adequate control over what was going on and where the public money actually went. So the idea that you can divorce 52-A from the three-pronged TML test it turns it on its head. Why would you ever do that? If that's the case, then there are no requirements under 52-A except that a city somewhere or a county somewhere says this is for economic development. And so we could go to Blooming Grove, Texas, or Dawson, Texas, or Frost, Texas, small towns in Navarre County, and they could pass a resolution saying that only white men can benefit from this economic development initiative where we're going to go ahead and have a new service station or a new 7-Eleven or a new grocery store or whatever. Obviously, when it says notwithstanding any other provision, it can't mean any other provision. It can't. There has to be some controls on it. And freeing 52-A from the TML test creates the opportunity for abuse, very much for abuse. Because then who's going to actually rein
So
them
did
in?
your clients abuse this opportunity?
I'm sorry, Your Honor.
Did your clients abuse the opportunity?
No, don't believe we did at all.
You gave millions of dollars to Forest County Industrial Foundation.
We did. We over 11 years, and we got something in return for what we were doing. And I guess if the court
Isn't
is
it
saying,
still there?
sir,
Isn't it still there? The building?
Gander Mountain is not there. The beneficiary of the funds is no longer there. If you read the AG opinions, I realize they're AG opinions, they aren't court cases, but the AG opinions tie the person who's providing the public purpose with the recipient of the funds. The person who gets the money has to do the work. And yes, Gander Mountain is gone. The building is still there.
But CIF got the money.
See, actually it went into a blocked account that was controlled by CIF and by the bank both. Once the money came to us, we put it in the blocked account, we lost complete control over every bit of it. Every bit of it.
Well, except that you had the ability to bring suit if it didn't go where you had contracted for it to go.
Had that happened, we probably could have brought suit. But for the period of time that Gander Mountain was there, whether it did a good job or a bad job of generating economic development opportunities wasn't really the issue. It was doing something. It was giving us something back in return for our money.
Ad valorem taxes.
Ad valorem taxes today? We got some ad valorem taxes. Yes, we did. We still get it. Actually, somebody else pays it now. I'm not sure we collected it because of the bankruptcy after that, but because the lessee was responsible for that. And there are at least 3 facts that demonstrate, I think, beyond any real argument that there is no control. There is no adequate control here. Control has the idea of being able to actually influence in some direction the activities of another. And we had no control. We had no adequate control at all.
Okay, you've inserted the word adequate control a couple of times. So
Yes,
let me focus on that same question I asked opposing counsel. Do you disagree initially? And what I'm trying to do is what's our standard of review? What's our, we got a summary judgment case. And so is this a pure legal question or are there fact issues? And if there are fact issues, is it a fact of, is it an economic development and the adequacy of controls?
I don't believe there is a fact issue on the adequacy of controls. We could argue about whether the public purpose was sufficient to justify the money. That might be a fact issue. And our argument would be that the cessation of public purpose means there's no longer a public purpose being served.
Well, doesn't that depend on what the parties agreed the public purpose was?
The public purpose was the development of the economy and the creation of the retail center. And the retail center, if you read our brief, read the facts, is the Gander Mountain facility. It's not the 132-acre development.
Well, doesn't that depend on how you define Gander Mountain facility?
It's 10 acre. Yes, sir.
It doesn't say Gander Mountain store or
Actually, it does.
franchise.
Actually, it does.
And there are other, I mean, this was about developing 123 acres,
132 acres. correct.
132. Okay, I transpose.
Yeah,
But
you did.
My point is that there was more than just the Gander Mountain store that was contemplated, and the taxes that are still being collected on the other areas of the development are what's at issue now in this proceeding, since Gander Mountain is no longer generating sales.
And that's the beauty about the second element of the TML test, is that adequate control has nothing to do with any of those facts. Adequate control really focuses on whether the city or the county had the ability to actually make something happen. And as my colleague, Mr. Cudnick, has pointed out, we really did. Our obligation to pay was absolute and unconditional, period.
But you made a store come up out of the dirt in 2004, a $10 million store. At
We
that,
did. We helped fund it.
yeah, I mean, part of this, that's what this agreement was for. And if that store didn't come about, you didn't know a dime.
Yes, agreed.
And so 132
Acres. correct.
acres is developed. I mean, there's a Home Depot there, according to the briefs, and apparently some other stores that are still generating sales tax.
They are.
And the valuation is still generating ad valorem taxes.
And if you were arguing about the first element about whether the public purpose had been served, all of those facts would be relevant. Focusing on the narrow issue, and I know courts like to decide matters on narrow issues. The narrow issue having to do with adequate control is pretty much uncontested. Our obligation to pay was absolute and unconditional. And I think we tried to actually, it's a reasonable inference that the city and county tried to negotiate something reasonable in there. Obviously, it was rejected.
But under a contract, it's always going to be what you agreed to on the front end. And what the city and the county agreed to was to commit a future stream of revenue to repay a loan at the time the loan was being made and at the time the building was being built.
Agreed. Every contract that it's ever entered into is subject to the Texas Constitution.
And so
Especially.
help me understand why, if they got what they paid for, which was a development, and they got the ad valorem taxes in perpetuity on that development, why did they not get what they agreed to and that they are obligated to pay out over the life of the contract?
Gander Mountain walked away with $6 million still on that loan. We're still on the hook to pay for the loan while they're not performing their part of the bargain. That's the point of the adequate control.
But
There
they
has to
built
be a
the building.
return on your investment.
They built the building that they were obligated to pay or build. And you committed the city and the county to pay this portion of their sales tax for the 10-year, 20-year period, whatever it was. And I'm looking for what gives the city and the county the right to reevaluate the deal that they cut in 2004.
I think we have the duty, number one, to do it. But in spite of that, the contracts never met the TML test ever. And it's not an abstract proposition. TML is not there. It isn't there. And for a period of time, truckers parked their rigs in the parking lots there, and we had trouble with prostitutes and drug sales. I mean, it was not it's a public nuisance, but not a public purpose. The TML test requires adequate control to make sure we get not just part of the bargain, but we get our bargain. We get what we bargained for. And between the lease, which doesn't require them to operate for one day, they have to open the store. That's what the interlocal says, but they don't have to operate at all. And the store is not.
But that's what y'all bargained.
The public purpose is generating business, jobs, and taxes. That's what it's doing. That's the public purpose here.
So if I understand your argument, the agreement was void.
Yes. And if you look at the record, the city had no idea what the lease actually said. Why? Because we didn't negotiate the lease, we didn't negotiate the loan, we didn't negotiate the deed of trust. We had no input into any of the transaction documents. Were we naive, perhaps? We were naive perhaps, but that's the way it actually happened. Everything was done without us being a part of it. The only thing that the city and county agreed to do was to be a perpetual ATM or debit card of public funds, taxpayer dollars, to pay for a loan for a business that's no longer there. Those contracts were always void. They were. Nobody knew it. We hadn't seen the lease.
So who's on the hook for the 11 years of payments that the city and the county illegally paid to CIF?
City and county aren't looking to get that money back. We aren't trying to recoup it.
Well, isn't that because they're the ones that paid the money? So they're not, I'm talking about the taxpayers of Nevada County. I mean, if this were void from the
Inception.
beginning.
They were, Judge. I mean, they don't have adequate controls. They absolutely do not satisfy the second element of TML. And like, maybe the answer to the question would be this way. If we were trying to get back that money, and it wasn't 9 million, we paid about 2/3 of it, so it might be 6 million. If we were trying to do that, that would be a whole different case, obviously. It would be a very different fact situation. And you'd have other kinds of legal principles that would come into play a lot from equity. For example, if I hire my neighbor, 12-year-old boy, to mow my lawn and agree to pay him in a written contract $25 a week to do it, later on he realizes that really he shouldn't be doing it. He should charge twice that much, and he wants to breach the contract. I sue the kid because I want my lawn mowed. He's going to say I don't have the capacity to contract. Correct? And what would happen in a case like that is I couldn't make the little 12-year-old give me all the money back, right? Because he's earned some of it. The principles of equity would essentially balance that out. And the kid would get to keep the money, but on a going forward basis, the contract would be void. And that's what would have happened had we tried that case. We're not trying to get our money back. Keep the cheese. We just went out of the trap. That's kind of the way we're looking at it, if you will. So anyway, in terms of any alleged controls in the agreements, they're completely illusory. We have no ability to control any outcome except for to write the check, put the money in the account, and it goes where it goes. This loan was renegotiated 5 years in. And the loan itself was obviously a very bank-friendly loan. It was a 5-year loan with a 20-year AM. So most of the early payments went to pay interest. We had no say in that. Again, were we naive? Yeah, maybe we were naive.
But the
Contract.
the agreement that y'all were dealing with was with CIF.
Yes,
And then
but the bank being a third-party beneficiary.
who is CIF?
The Corsicana Industrial Foundation is a local nonprofit corporation that was formed before the passage of Article 3, Section 52-A to assist local economic
Who
development.
controls it?
Back then, it was Mickey Hillock, Barbara Moe, Kim Wyatt were the board members.
Who appoints the board members?
They're on their own. Completely. We have no control over them. We wish we did sometimes because there are things we don't want to always have done.
But CIF was the buffer between the tenants, and they were the ones that were controlling the renegotiation of the loan.
Yes, they had all to say. We weren't consulted. We had no say in any of it.
But but you were contracting with CIF and you were looking for CIF to protect their interest.
CIF and Gander Mountain both actually. The RCDAs, the first two contracts were with the Industrial Foundation. Gander Mountain became a signatory to the interlocal agreement that was signed later, and the bank became a third-party beneficiary.
Okay. Need to go back to my question, and then I'll give you a couple of minutes to wrap up. But you said you didn't think there was a fact question here on the initial part, which was the economic benefit. And then, or I thought you did.
No, I think we could argue about public purpose, and the way that I would try to make that a matter of law would be to argue that the law requires that when the public purpose ceases, then the payment cease. Otherwise, there's no question that public purpose was realized for some period of time. It's the second element of the test, the adequate control element, where there is no argument. The city and the county had no control over any of this. We had no way to ensure that we.
I realize from a recent Texas Supreme Court case that there are some things that are, even if the parties disagree on the facts, that there can still be a legal issue, only a legal issue. But I think they disagree with you as to whether or not there is a factual question on control, at the very least.
They might disagree, but the three facts we rely upon are really very straightforward. Number one, that the absolute and unconditional nature of the payment. Absolute and unconditional means absolute and unconditional. And apparently in this case, this contract even overrides constitutional controls put in place to protect taxpayer dollars. Number one. Number two, the lease didn't require that the economic engine, the economic development engine actually operate, period. Gander Mountain could have stopped at any time it wanted to under the lease, and we had no ability to provide otherwise. The lease allowed them to, the interlocal required them to open, the lease allowed them to not operate at all. And then the third argument is, or the third point is actually a rather obvious one. If we had control over Gander Mountain being there, we'd have exercised it before we filed a lawsuit. We had no ability to make Gander Mountain stay there and do anything. When they left, they filed bankruptcy, they're gone. And the other provisions that they argue that provide control really don't. They argue that the ability to get information is a control. It isn't. If we can't do anything with the information, it's not really helpful. They cite one of the things, a Ken Paxson opinion that talks about information being controlled. But if you read that opinion on down, the AG's office actually kind of helps the requestor there by pointing out that in that case, it was a county ambulance service situation. The county had the absolute right to terminate the contract anytime it wanted to. And so the ability to get information through an audit and to terminate the contract gave control. Other than that, we had the ability to pay the money. That was it, period. We could do nothing else other than give the money that we received from the comptroller's office. And let me add one more thing.
Yeah, I'll give you 3 minutes to wrap up.
You bet. The court might ask the question then, if the language in 52-A where it says notwithstanding any other constitutional provision doesn't mean what they say it is, well then what does it mean? And there are at least 6 other provisions in the Texas Constitution that impact spending public dollars on private development. You can go to Article 16, Section 6. It says you can't pay money for a private purpose, for example. Article 11, Sections 3, 5, and 7 create debt limits. If the debt's more than 1 year, you have to create a sinking fund. You can't become a stockholder in the corporation of a private entity. Article 8, Section 3 allows for public taxes to be spent for public and collected for only public purposes only. So there are other constitutional provisions that go all the way back to the founding of the I guess the refounding of our state in 1876 with the Constitution that do impact the government giving money to private entities. The language in 52-A was obviously meant to say, we don't want Article 16, Section 6, Article 11, 3, 5, and 7, Article 8, Section 3, or even Section 351 to interfere with this. From this day forward, economic development is a public purpose, and so it's entitled to be treated as such. Nothing about that says that it's free from the TML test at all. So if anybody has any questions, Justice Johnson or Justice Smith, I'd be happy to answer them. I don't think the record's clear. On adequate control, there is no fact issue. That's where I want to land. It's a narrow ruling. I get it. We can argue about public purpose and we can argue about the third element, but on adequate control, it's crystal clear we had none. So appreciate your time, y'all.
May proceed when ready, counsel.
Thank you, Your Honor. Justice Scraft, I think you hit the nail on the head. The city and county got what they paid for. If you look back at what they contracted for and what they entered into these agreements, and their resolution that authorized the RCDA says the county and the city realized the economic advantage for development of a retail center. That's what they got. They got the very thing that they contracted for. And this is what distinguishes this case from many of the cases they talk about, because in a lot of the other cases, we're talking about something where the private company has some ongoing obligation to provide some services in the future or do something in the future. In this case, what we have is the foundation before they got money fulfilled the very purpose of the agreement. They built the store. And that store gave benefits to the city and county, and that's what the city and county wanted, and that's what they contracted for. It gave them not only the sales taxes from that store, it gave them property taxes from that store, which still goes, all the development around, and the sales tax and property taxes and jobs from all that. The record also shows that the shopping center wouldn't have been developed without the Gander Mountain store, so they got what they paid for. What they're trying to do now is change and say, well, we really wanted something else. I mean, the city and county, they were free. If what they wanted to do was generate or grant sales tax incentives because Gander Mountain was going to employ 100 people in the community, they could have contracted for that. And then there'd be some ongoing way for maybe to get out if they didn't employ 100 people, but that's not what they wanted. They wanted construction. And that's what this case is about. I want to talk a little bit about the TML test and this control thing. I'm not afraid of TML. I just don't think it applies. And I know there are a few AG opinions that have said so it applies. If you look at those opinions, first of all, AG opinions are not the law. They are an opinion from an elected official. They're not the law. They're not controlling. And if you look at those opinions, they cite nothing for the proposition. I mean, the first one cites back to TML, but again, look at TML. TML is a section 52 subsection A case, not an economic development agreement case under 52-A. When you look at the controls here, again, you got to put it in context. The purpose of the controls is to ensure the public purpose would be fulfilled. Again, go back. What is the public purpose? The construction of the facility. How did these agreements ensure that that would be accomplished? Well, I'll tell you. You look at the RCDAs, sections 2.2 and 2.3. They limit the incentives to, quote, the construction of real property. They prohibited the foundation from using the fund for any other purpose. And they compelled the foundation to provide written reports regarding the use of the funds and the status of construction. The interlocal agreement, section 4, required the foundation to use any public funds, quote, for the sole and exclusive purpose of paying the principal and interest on the loan. And section 9 mandated that all the money from the construction loan shall be used to construct the Gander Mountain facility. So the controls made sure that the foundation, and let me point this out, Gander Mountain was not the recipient of any of these public funds. It was the foundation. All the money went to the foundation. And the foundation did what they contracted to do, which was build that store to increase the economic development for the city and the county. Last point I'd like to make, one of the cases that the city and county side in the AG opinion about ambulance services, it said an annual accounting of funds is sufficient control. Here, not only do we have annual accounting, we have quarterly accounting, and plus all the other controls I've talked about. So I don't even think you need to go down the TML control test, but if you do, I think these agreements have adequate controls to ensure that the public purpose, the construction of the building, was fulfilled. Unless there are any other questions, that concludes my argument.
Thank you, counsel. This case is submitted. You cited a case that was not in your brief.
Yes, sir.
You have not had a chance to see it or respond to it. You've got until Friday to supplement, provide us that citation and any argument. And then you'll have 3 or 4 days into next week. I'll say Friday of week after to file a supplemental brief in response to that. And any other authorities or arguments y'all want to make. But we thank y'all. And this case is submitted. Y'all are excused.
Thank you.
That concludes our oral arguments at Blinn campus for the fall of 2023. And I didn't tell this audience earlier, but this is our 10th time to do it in this location. We did it last year out at Blinn's Relish campus, and then we did it 1 year on Zoom. There will be no money paid to the person who can guess what year that was. But you know, this is a great opportunity. I appreciate y'all coming out, on this, Wednesday afternoon, and, y'all have a safe trip, and I understand the weather's supposed to get cold and, dreary, Steve, is that right? So, y'all take care. Kill your mic if you hadn't already, if you would, please.
It's all.
It's off. It looks on from here.
Last time I argued, I didn't shake your hand, so
So-
you're supposed to shake your hand, right? Good
Oh, I
to see you, Judge.
Good to see y'all for coming.
You bet.
Appreciate you.
Good to see
Thanks,
you.
Judge.
I know.
Justice Smith.
I'm not thanking you for coming back. You're always.
He's here.
Good
Good to see you.
Judge Rory Ryan. We haven't met, I don't think, in person. Good to meet you.
He's one of those used to be's at Baylor.
Oh, okay. About 20 years, 20 years. In fact, I started teaching, I believe, the year that you were elected chief. 04?
Oh, no, yeah, I was elected chief in 04, became chief in 03, was first elected to the court in 98. Started serving in
All
99.
right. So I was kind of right.
Yeah, close enough. Is it Cody?
That's it. Yeah.
All right, Cody. I don't have a picture of him, but the guy's name is Matt Staten.
State, yeah.
Oh, yes, I do have a
Beverly-
picture.
Yeah, she showed me, yeah, she just showed me a little bit ago, yeah.
And if that's not
He
your
looks-
doppelganger from 10 years
Yeah,
ago,
He looks familiar, honestly, and not just from the mirror, but I don't know, I wonder if I met him.
he's a partner at Bond Ellis, Epic and Shaker.
Okay. All right. well,
Come up here, Castle. I want to show you when I saw this guy,
He is a twin, so it's possible.
yeah. Oh, do you actually have a twin?
Twin sister.
No kidding. That's crazy.
We have a
When
triplet out there.
I saw him come across the back of the courtroom, I said, I asked the question. I said, "Did you used to work at the Tips Court of Appeals?" I thought it was this guy, and his name is Matt Staten. And I mean, I looked at him and I'm going, you know, and then it dawned on me, this would have been him 10 years ago, you know, maybe longer than that, you know. So yeah, it's probably more like 15, because I think he was a briefing clerk for Rex when Rex was chief, and Rex resigned in 2003. So, but anyway, I was going to tell both of y'all in private, but Terry's gone. Great argument.
Thank you.
I mean, it did not pause other than when I was slowly asking the questions. So y'all have a great day.
Thank you very much. What, you mean something about the concept of bulldog flying? Yeah.
No,
Reaching in and grabbing it by the teeth?
All right,
Rex.
Not a fact.
Rex.
What you wanna do? We're here.
We need to go to the run.
Yeah.
Matt already gone.
No, I'm fine.
I actually.
Yeah. Yeah, now, but you know, our attorneys, you know, they do it for 50,000, probably. Yeah. Yeah. So it's. Yeah. Okay, sure. So, pretty good cases to argue from, and I really like. That last one, they're both good arguments. Also, it's an interesting dilemma, because, you know, I understand. Both sides. But I'm very- Thing about it, the government will never be that easy for it. Their business council You don't have this before? Oh, you have the contracts, contracts, and the reason he does, is because I don't know anybody who is more enthusiastic about contracts. Because or more novel. Teaches our contracts, teaches them, a little bit of legal accounting, also other classes. Take contracts. They have there.
Yeah, I didn't, and it's.
Oh, I love it. We're gonna have to probably have 3 or 4 meetings to kind of figure out what we think. Yeah. Well, thank you for coming today. Thank you. Like, we'll sure we'll talk about. I know we don't have time today. We got probably even right. That'd be great. Yeah. No, I think, let's see, where we, hey, thank you so much. Second one is great. Said as we can talk about that. You can see how these guys. I'm gonna go back. It's deep down, I've told trial that. I'm gonna go back. You know, it's kind of almost back. I'm gonna go back into that. It's a good one to, you know, this. I'll tell you. Pretty something, I'll look at it all, so the pretty goes into. Even more. I mean, like, there's like, I can see it, but I've seen it, I've walked into the chaos. Yeah, that's awesome. We were all excited about that case, you know, kind of, we're great attorneys, you know, we had this panel of we got. But it was good to hear them both. I love the arguments. Yeah, they want to solve. I agree, I agree with both. Yes, we're right there. Yes, that's a great education. Thank you, Roger. Anything else from the players? Thank you, and thank you.
Lisa, before you get too involved in stacking, we're gonna take 5 round tables and put them over here. Middle each here.
Oh, okay. Well, no. Like this morning, I really put it after the different case themselves, on 2 sides, we're talking one side, and those are the ones we put out here. But we just can't give those shirts out.
How many chairs put these tables?
Oh, I need to look.
Is it just sitting in there on the copy?
It took me,
Yeah.
copy after you do it.
Oh, no, yeah, like the- There's like that. you know, once that work is done by you ahead of time, and make there's 5, but they're gonna run 30.
Pick one of the plans, and I think it's 6.
Because I know that we, you know, we provide a little information. Thank you. Kind of how we have done it, how. Second. Oh, I'll read it out 1%, we got it. But some of these people, you know, they're, in prime time. I didn't encourage what I'm doing. But now.
Did that say 5? I think it was 5 to the right of the stage.
Now.
Yeah, it's 5.
And then 4 cocktails to the left.
Right,
Okay, those are cocktails.
Huh?
you know, it's not.
You see that part? I would leave me. I don't know how many there are. Probably 2 tables.
Yeah, 2 tables, for food.
Well, I was right. Sit down.
And we have the ones that are in classroom,
So you can see the. Morning, you know, we got a few left. There were a few scattered features that we all, you know, that. Thing I can do.
Great, Allie. Those are gonna be cocktail tables. Yeah, the small ones.
Okay.
Yeah, a couple.
Instead of the cocktail table, so it's small round? Small round, okay. So it's still certain, yeah. But I didn't know what to do.
I'll mess with it.
Come in, Lisa. Okay, 4 of those.
All right. You okay?